Selamat pagi, salam sejahtera, Om Swastiastu, salam kebajikan, Namo Buddhaya. Pada pagi hari ini, mohon izin saya akan menggunakan bahasa Inggris, ya. Jadi Bapak Ibu yang berkenan untuk mendengarkan dalam bahasa Indonesia, nanti bisa pilih ke channel bahasa Indonesia. Sebelum saya lanjutkan, ya, saya akan menyerahkan ini untuk ada housekeeping sebentar kepada Mas Tafan. Silakan Mas Tafan.
Ya, Bapak Ibu, dalam pertemuan, selamat datang dalam pertemuan hari ini. Dalam pertemuan hari ini kita menyediakan fitur interpreter. Jadi Bapak Ibu, bagi yang masih baru baru bergabung, silakan Anda mengklik tombol bola dunia bagi yang bergabung dari laptop, interpretation. Lalu untuk mendengar dalam bahasa Indonesia, silakan klik interpretation lalu pilih channel Indonesian. Saat Anda sudah di situ, Anda sudah bisa mendengar terjemahan nanti dalam bahasa Indonesia. Nanti kalau bagi mereka Anda yang ingin mendengar dalam bahasa Inggris, tolong klik dalam bahasa Inggris, ya, klik interpretation lalu klik English. Sedangkan bagi para pembicara harus ditekankan sekali lagi bahwa pada saat mereka bicara dengan bahasa Inggris sudah tidak perlu pindah-pindah lagi, ya, dan memilih channel bahasa Inggris. Bagi yang bergabung lewat handphone, ini agak lebih tricky, ya, karena nggak langsung kelihatan tombolnya. Jadi Bapak Ibu silakan klik tombol titik 3 atau more. Ya, ini biasanya kita swipe sebentar, nanti sampai tombol more-nya terlihat. Lalu nanti klik language interpretation, lalu pilih Indonesian atau English, dan jangan lupa pencet di kanan atas done. Ya, jangan lupa klik done ya, soalnya banyak banget orang yang mengaku nggak bisa mendengar interpreternya, tapi karena mereka belum pilih yang done, ya, yang nomor 4. Gitu ya. Sampai saat ini saya ingin memastikan semua orang udah bisa mendengar atau mengakses bahasa masing-masing. So, if you would like to listen in English, please click interpretation and choose English. And you don't need to change the channel when speaking. Don't worry, the resource person and interpreter will be able to hear you. And if you are accessing Zoom through handphone or iPhone or iPad, you can choose the more button, like an ellipsis, and then choose language interpretation, and then choose either English or Indonesian channel, and then click done. Thank you.
Baik, terima kasih Pak Sasvan atas penjelasannya. Ladies and gentlemen, without further ado, I will start this event this morning. My name is Ari Afriansyah. Currently, I am the chairperson of the Center for Sustainable Ocean Policy, Faculty of Law, Universitas Indonesia. I am very glad to welcome all of you to this very important event of guest lecture or international webinar that will be presented by Professor Makoto Seta. So if I may invite Professor Makoto Seta, yeah, you can see Professor Makoto Seta. He is associate professor from Yokohama City University. He got his LLB from Waseda University, and he have 2 LLMs, one from Waseda University and also from London School of Economics and Political Science in UK. And he got his PhD in Public International Law in 2015 from Waseda University with the dissertation title of the development of universal jurisdiction under the law of the sea. And he has so many publications in which majority in the field of law of the sea. And we are very grateful that Professor Makoto is a very well-known scholar in Japan. And today he's going to share his thought, his experience, his research, past research, so we can learn from him about our context. Ladies and gentlemen, if I may share to Professor Seta, that here I can see so many participants coming from universities, lecturers, professors, and also I've seen that I saw so many my dear colleagues, yeah, my dear students, and also my colleagues from the relevant ministries, ministries of foreign affairs, Ministry of Fisheries and Ocean Affairs, Ministry of Law and Human Rights, the Navy, yeah, and also from the Indonesian Coast Guards. So this is a very good participants that we have this morning, and for your information, that the registration that we have is surpassed the maximum limit. We have 300, and more participant is really wish to join this webinar. However, I can see maybe some of them maybe will come a bit later on. However, we must start the event on time, and we are really looking forward to this insight. As we all know that Indonesia has a vast area of waters, and also we have so many incidents with our neighbors, and how we as a coastal state have rights and duties, yeah, to foreign elements. This is something that Professor Seta will share with us with his background and context. Okay, without further ado, I think the time I will give to Professor Seta for about, as long as you are able to give the presentation, and then we will continue with the question and answer. Professor Seta, time is yours.
Okay, thank you, Ali. Thank you very much for your kind introduction. And selamat siang, kenalkan, nama saya Seta Makoto. So that's almost all the Indonesian words I know. And one additional Indonesian word I know is tidak apa-apa. So one of my close friends lived in Indonesia, and he said Indonesian often said this word. As far as I understand, this word means never mind, and shows how generous Indonesian people are. And so let me share my slides. Okay. So can you see my slide? Okay, great. Okay, so my name is Makoto Seta, an associate professor of international law at Yokohama City University, Japan. So do you know Yokohama City? So recently, Yokohama Port might be notorious as a port where Diamond Princess was calling at. So Diamond Princess is a cruise vessel in which COVID-19 spread. So actually, Yokohama City is a good port city with many sightseeing spots. So if you have an opportunity to come to Japan after this pandemic is over, please visit the city. And this is Yochi, a cute mascot character of my university. So some of you might have the Japanese image as such cute character. So before starting my presentation, I would like to extend my sincere gratitude to Ali and his colleagues at Center for Sustainable Ocean Policy, Indonesian University, and the Ministry of Foreign Affairs, Japan, to give me the opportunity to provide a lecture before a distinguished guest. So I'm really surprised at the number of participants. I'm delighted to exchange views with the kind of practitioner in various fields. And I thank all of you to participate in the Zoom lecture, even in this very early morning in Indonesian time, right? So the title of my presentation is Enforcement of Law and Regulations of Coastal States. So this is the contents. After introduction, I will explain rules of international law, which are applied to law and regulation enforcement by coastal states. Then I highlight the critical role of domestic law when coastal states take law enforcement measures in accordance with international law. And finally, I make a conclusion. So, introduction. Okay. So this is a lecture provided by a Japanese academic, me, at the Indonesian Center, CSOP. So first, I want to highlight the similarity between the two states. Needless to say, both Japan and Indonesia are located in Asia, as the left map slide indicates. So, right? And both of them consist of many islands. Japan has almost 7,000 islands, and Indonesia has almost double. So 15,000 islands. So I know that so there is a kind of a controversy over the number of the islands, right? So because you have so many islands, so we can say that so these two states are island states. So currently, maritime areas are mainly regulated by the UN Convention on the Law of the Sea, so-called UNCLOS, so which is perceived as a constitution for the ocean. According to this convention, coastal states can have the maritime area based on their land territory. So land dominates the ocean. So coastal states can have territorial water up to 12 nautical miles from the baseline. Contiguous zone, so up to 24 nautical miles. And very huge, vast exclusive economic zone, EEZ, up to 200 nautical miles. And if some geological conditions are met, a continental shelf can be extended beyond 200 nautical miles and up to 350 nautical miles. So this area is continental shelf. What I want to emphasize here is the fact that coastal states do not have sovereignty itself over exclusive economic zone and continental shelf, but sovereign right. So red circle one, sovereign right. So which looks similar but different from sovereignty. The scope of sovereign right is basically limited to natural resources. Therefore, coastal states can enforce their domestic law and regulations for managing resources in the EEZ and continental shelf, but they cannot enforce their own laws and regulations which are not relevant to resources. Having said that, so thanks to the numerous islands, so both Japan and Indonesia have vast maritime zones based on the UNCLOS. In the case of Japan, so currently, this pocket is also accepted as an extended continental shelf. So it has really huge maritime areas compared to its land territory. And in the case of Indonesia as well, so in the same way, so it has really huge maritime area. So this is a chart on the size of land and maritime areas of both Japan and Indonesia. Although I can't find the statistics on the size of the Indonesian extended continental shelf, it is obvious that they have a huge maritime areas. And so they are pictures of both Japanese and Indonesian beach. I have a good memory of the island beach. So once I participated in the conference on the law of the sea, which was held at Andaman and Nicobar Islands in India. After participating in the conference, the Indian host institution organized an excursion to go to the beach. And this is a picture of the beach. So actually it was more beautiful than this picture. But when we got on the sightseeing vessels, its announcement said that the Andaman Nicobar Island have the most beautiful beach in Asia. Then one of my Indonesian colleagues complained that the Indonesian beach is better. And I claimed that the Japanese ones are also nice. So Asia Pacific has many beautiful islands with beaches. So personally, so far, I have been to Indonesia twice, but always to Jakarta. And I have to confess that my Indonesian friends tells me that other places such as Yogyakarta and Bali are more exciting. So I expect that Ali will invite me to other place next time after this pandemic situation is over. Okay, thank you. So anyway, thanks to huge exclusive economic zone and continental shelf, both Japan and Indonesia have many resources at sea, including fish stocks and hydrocarbon or other mineral resources. So, in order to protect such resources, law enforcement by coastal states is essential. However, law enforcement at sea is much more difficult than one at land because it requires facilities and equipment, so including vessels, as well as training of personnel. Moreover, maritime order is often disturbed by foreign states. So left picture is a picture of an autonomous underwater vehicle, AUV, so which was found recently and is said to be made in China. The right one is picture of the explosion of fishing vessels. I know that Indonesia suffers from the IUU fishing conducted by foreign vessels. So in order to deter such fishing, Indonesia took comparative radical measures. So this policy was led by the former Minister of Marine Affairs and Fisheries, Ms. Sushi, right? And she is also famous in Japan because of her name. So do you understand why? Yes, it sounds like sushi, Japanese cuisine. So I took this picture at sushi restaurant I like. So Ms. Sushi regulates fishery. So it is funny from the perspective of Japanese language. So she once appeared in the famous Japanese manga named Gorgo 13 in this way. So I'm not sure to what extent Indonesian people know this fact, but this right picture is an article of Compass, so a well-read newspaper company in Indonesia, right? So I believe it is known to some extent. So personally, I feel this manga, or so her appearance in manga is a little bit rude against a foreign high-ranking politician, but generously she said it is not a problem at all. And when she came to Japan, she allowed Japanese media to take her picture with the said manga. So as the left picture indicates. So in this way. So the picture taught me the reason why she is popular among Indonesian people very well. Okay, so anyway, I conclude my introduction and moving to international law rules. So my specialty. So more serious talk I will make. So the picture at the center is a vessel named Reimei, the largest vessel of the Japanese Coast Guard, JCG. Japanese Coast Guard, JCG. So JCG played the central role to enforce Japanese law at the maritime area. Traditionally and historically, so such law enforcement activities were not regulated by international law because such activities are the very center of sovereign functions. However, now many rules of international law are applied when state agencies such as the Coast Guard engage in law enforcement at sea. As I said, coastal states have different authority over different maritime zones. These rules of maritime boundaries are essential. Also, in the undelimited maritime area, where more than two states claim their position as a coastal states, states owe special obligations. Furthermore, the law enforcement agencies need to comply with maritime police law as well as human rights law. Moreover, when the Coast Guard agency used firearms, they must be careful not to violate the principle to prohibit the use of force. And when public vessels of other states are involved, the rules of state immunity are also applied. So in this way, multiple rules of international law are applied. So it looks a little bit difficult for law enforcement agencies to comply with these rules. To put these rules from the perspective of the entity which conducts law enforcement, it turned out that they need to take into account three factors: how to enforce law, and against whom, to whom, and where. So these three factors must be considered, taken into account. The relevant rules can be sorted in this way. After addressing obligations in undelimited maritime area, so this purple one briefly, I will explain these four rules one by one. Okay, so first, I briefly explain obligations in undelimited area. So this obligation is provided in Article 74 and 83 of the UNCLOS. 74 is related to undelimited maritime area in EEZ, and 83 is associated with a continental shelf. Both articles are almost identical, and its first paragraph indicates the method of delimitation. According to both articles, delimitation shall be effected by agreement. So without delimitation agreement, states with opposite or adjacent coast cannot have established maritime delimitations. However, as we can easily imagine, negotiation of maritime boundary delimitation takes time. So paragraph 3 provides the obligation of states during this transit period. According to this paragraph 3, states have an obligation not to jeopardize or hamper the reaching of the final agreement. Therefore, if Coast Guard agencies police other states' vessels in the undelimited maritime areas, and those policing activities are regarded as jeopardizing the reaching of the final agreement, it can violate this obligation. As for the detail of this obligation, please read this report, published by the British Institute of International and Comparative Law, BICO. So I'm one of the co-authors of this report, and I'm proud of the kind of content of this report. So if you have an interest in it, so please read it. Okay. So next, I will explain the Maritime Police Law. So this law is customary international law and has been developed through several cases, even before UNCLOS was adopted. Its root is in I'm Alone case in 1935. The joint final report of the Commission in the case of the I'm Alone said that states shall use states shall use necessary and reasonable force for the purpose of effecting the objects of boarding, searching, seizing, and bringing into port the suspected vessel. And this rule is confirmed in report published by the Commission of Inquiry between UK and Denmark in the Red Crusader case in 1962. Also, this rule is provided in the soft law documents, such as Basic Principles on the Use of Force and Firearms by Law Enforcement Officials, published in 1990. Moreover, so this rule is now provided in some treaties. For example, Article 22(1)(f) of the Fish Stock Agreement provides the inspecting state shall ensure that its duly authorized inspectors avoid the use of force except when and to the degree necessary to ensure the safety of the inspectors and where the inspectors are obstructed in the execution of their duties. The degree of force used shall not exceed that reasonably required in the circumstances. So here we can confirm that the force used in maritime law enforcement activities must be reasonable. After the UNCLOS was adopted, so this maritime police law has been developed by the UNCLOS tribunals. So they are ICJ, International Court of Justice, International Tribunal for the Law of the Sea, ICROS, and the Arbitral Tribunal. So in the MB Saiga case, the ICROS, International Tribunal for the Law of the Sea, confirmed this rule in 1999. Also in the MB Virginia G case in 2014, the same tribunal said that the principle of reasonableness applies generally to enforcement measures under Article 73 of the Convention. It takes the position that in applying enforcement measures, due regard has to be paid to the particular circumstances of the case and the gravity of the violation. In this way, the application of the principle of reasonableness is not limited to the use of force, but expanded to police activities in general. Having said that, so this article is provided, so this Article 73 is a provision applied to exclusive economic zone. So this principle is applied only to EEZ areas. And in 2014, the Arbitral Tribunal under Annex 7 concurred the position of the ICROS in the Arctic Sunrise arbitration. Then, in 2016, in the Dazjit Integrity Arbitration, the Arbitral Tribunal under Annex 7 said the exercise of enforcement powers by a coastal state in situations where the state derives these powers from provisions of the convention is also governed by certain rules and principles of general international law. In particular, the principle of reasonableness. This principle encompasses the principle of necessity and proportionality. These principles do not apply in cases where states resort to force, but to all measures of law enforcement. Article 293(1) requires application of these principles. They are not incompatible with the Convention. So this award is quite important for the development of maritime police law for the following 2 points. First, the application of reasonableness is expanded to maritime areas other than exclusive economic zone. So now it can be said that it is applied to all the maritime police activities conducted by coastal states everywhere. And second, it clarifies the contents of reasonableness. So it encompasses the principles of necessity and proportionalities. Actually, these principles appear in many contexts of international law, and probably it appears in the domestic law as well. So such as a condition to exercise a right of self-defense. So, but here, I want to highlight the fact that these 2 principles, so principle of necessity and proportionality, are also used in the context of human rights law, especially when we interpret the term arbitrariness. So let's look at the human rights law. So human rights law consists of many international human rights treaties. In the case of Japan and Indonesia, International Covenant of Civil and Political Rights, ICCPR's Universal Human Rights Treaty is important. In the case of other regions such as Europe, Latin America, or Africa, they have their own regional human rights instruments and own regional codes. But we Asia do not have such code. So the ICCPR is important, as I said. And under human rights treaties, state parties are obliged to protect human rights of individuals only when they are subject to their jurisdiction. So this is provided, for example, in Article 2 of the ICCPR. In other words, if an individual is not under its jurisdiction, a state does not owe the obligation to protect his or her human rights. Now, it is widely broadcasted that human rights of people in Myanmar is infringed. But both Japan and Indonesia are not regarded as violating human rights treaties because individuals are not under their jurisdiction. It is extremely difficult or almost impossible for states to protect human rights of individuals who are not under their jurisdiction and do not have any nexus. However, in the context of maritime law enforcement, so recently there is a tendency that the scope of the concept of jurisdiction in this context is expanding. For example, even on the high seas, if a Coast Guard agency, for example, repress the criminals, so like this way, so Coast Guard agency found the kind of illegal fishing activity and repress the criminal suspect. So like the case of picture. So such criminals are perceived under the jurisdiction of a state of Coast Guard. So if this Coast Guard vessel belongs to state A, criminals are regarded as under the jurisdiction of state A. So state A shall guarantee the right of criminals provided in the human rights treaties. So in this way, human rights law is applied to law enforcement activities. Among various human rights, in the context of maritime police activities, sometimes the right to life is relevant because if law enforcement agency use force, sometimes it could kill a person, and Article 6, Paragraph 1 of the ICCPR provides that every human being has the inherent right to life. This right shall be protected by law. No one shall be arbitrarily deprived of his life. So, whether the deprivation of life is arbitrary or not is vital when judging the legality of such deprivation. As for the notion of arbitrariness, according to the ICCPR committee, it is not to be fully equated with against the law, but must be interpreted more broadly to include elements of inappropriateness, injustice, lack of predictability, and due process of law, as well as elements of reasonableness, necessity, and proportionality. So, whether an action constitutes a violation of Article 6 or not depends on the principle of necessity or proportionality to some extent. And we saw these words when I explained Maritime Police Law, right? So I can say that the rules of human rights law are similar to Maritime Police Law rules. Under these two bodies of law, what the law enforcement agency is expected is not to take any unnecessary measure and take the minimum measures when they engage in law enforcement activities. Okay, next, I will explain the prohibition of the use of force and the threat of force. This principle is one of the most important rules of international law and perceived as jurisprudence. This principle is developed as jus ad bellum and currently provided in Article 2.4 of the UN Charter, which is duplicated in Article 301 of the UNCLOS. So, of course, this principle is applied to the maritime area as well. Actually, this principle has some exceptions, and one of them is the exercise of right of self-defense provided in Article 51 of the UN Charter. However, such exercise must fulfill several conditions, and one of the conditions is only when an armed attack occurs. So states cannot justify its use of force as an exercise of right of self-defense when there is no armed attack. Also, here I want to highlight the fact that law enforcement activities under domestic law can constitute a violation of this Article 2.4 of the UN Charter. So this is confirmed in the case between Guyana and Suriname in 2007. The maritime claims of these two states were overlapping. So there is undelimited maritime area. And in such an undelimited maritime area, one private company engaged in the development of hydrocarbon based on the concession with Guyana. So Guyana gave the concession to the private company, and that company engaged in the development. Then, in order to stop this development, a Surinamese Navy vessel was deployed, and it made a warning against this private company. So from the Surinamese perspective, it was a law enforcement activity against a private company that engaged in illegal development activities within the Surinamese maritime area. However, considering the fact that the development was authorized by Guyana government, the arbitral tribunal under Annex 7 considered the warning by the Surinamese Navy fall within the scope of the threat of force, and thereby violating the said principle. In this case, it is a Navy vessel that made a warning, but it is a law enforcement activity under the Surinamese domestic law. So, even Coast Guard activities can be regarded as the illegal use or threat of force from the perspective of international law. Next, rules of sovereign immunity. This rule is based on the Latin legal maxim par impellem non habet imperium, which means equals do not have authority over one another. This rule of immunity is not directly provided in the UNCLOS. What the UNCLOS provides in its Article 32 is that, with such exceptions as are contained in subsection A and in Articles 30 and 31, nothing in this convention affects the immunities of worship and other government ships operated for no commercial purposes. So this article is based on the fact that under customary international law, warships and government ships operated for non-commercial purposes enjoy immunity. So actually, this Article 32 is related to the territorial water. However, similar provision on the high seas are stipulated in Articles 95 and 96 of the UNCLOS. In the context of maritime law enforcement, this rule of sovereign immunity means that sovereign state cannot exercise jurisdiction over another sovereign state. And this exercise of jurisdiction includes police activities. So more concretely, states Coast Guard cannot police each other. So would you focus on this picture? So can you imagine what is going on? Can you guess? So this is a quiz. Would you guess? So this is a picture provided by Japan Coast Guard annual report. So the left small vessel. So this left small vessel is the Japanese fishing vessel. And the right big one, so this big one is the Chinese Coast Guard. So this happens around the Senkaku Islands, which both Japan and China claim their sovereignty. So the Chinese Coast Guard try to police the fishing vessel. And actually, from the Chinese law perspective, so this Japanese fishing vessel engaged in unlawful fishing. But so it engaged in lawful fishing from Japanese law perspective. So the Japanese Coast Guard tried to interfere with the police activities by the Chinese authority in this way, right? So yeah, so Chinese Coast Guard tries to police Japanese fishing vessel, and Japanese Coast Guard tried to stop it. Yeah, success. So thank you for the message. Yes. Okay. So the Japanese Coast Guard, but both the Japanese and Chinese Coast Guard vessel do not take any measure against each other, right? And because they know such unilateral law enforcement could constitute a violation of international law on sovereign immunity. So probably they understand that if they take some measure against each other, it would constitute a violation of international law on sovereign immunity. Okay, so it's another quiz. So would you see this picture, and what is it? So can you guess what is the situation? So actually, this is a picture of Japanese and Taiwanese Coast Guard using water guns. So they use water guns. So you can see many usage of the water gun, right? So why do both Japanese and Taiwanese Coast Guard use water gun and not actual firearms? So if you understand my lecture so far, so probably you can answer it. Yes, so both of them, of course, cannot use force. So because if they use firearms, so it would consider violation of Article 2.4 of the Article 2.4 of the UN Charter, right? So prohibition of use of force. And if they enforce their own law against each other, so it would also be regarded as a violation of the international law on sovereign immunity. So in order to avoid such a violation of international law, so they do not use firearms. So probably, as far as I know, the similar thing happens in the South China Sea, especially as far as I know, it happens between Vietnam and China. I'm not sure to what extent Indonesia also use this water gun, but especially in Asian water, Asian maritime areas, I think it often happens. Okay. So yeah, from here, I will tell how important domestic law is for the purpose of complying with international law in maritime law enforcement. So first, I want to introduce Japanese domestic law. As I said, in the Japanese legal system, it is a Japan Coast Guard, JCG, which mainly owes the responsibility to enforce Japanese law within the Japanese maritime areas. So paragraph 1 of Article 20 of the JCG Act provides that Article 7 of the law concerning the execution of duties of police officers, so that is law number 136 of 1948, shall apply mutatis mutandis to the use of weapons by Coast Guard officers and assistant Coast Guard officers. So I can say that paragraph 1 of Article 20 introduces the Japanese domestic police regulations into the JCG activities. And I would like to note the fact that this law number 136 of 1948 is applied within the Japanese land territory and mainly applied to the Japanese national. So the same treatment is guaranteed in the police activities conducted by the JCG. And it also requires police officers to use force in accordance with the principles of proportionality and necessity. Actually, paragraph 2 of Article 20 provides an exceptional situation to use weapons. According to this paragraph, when JCG officers find grounds to believe that no other means are available to stop the vessel in question that ignores JCG officers' order or resist JCG personnel in the performance of their duty. However, other states' worship and governmental ship are not subject to paragraph 2. So, worship and government ship of other states are expressly excluded from the application of paragraph 2. So this fact seems that Japanese intention not to enforce Japanese law against foreign state public vessels in conformity with the rules of sovereign, in the rules of state immunity. So next I want to address Indonesian domestic law. So honestly speaking, I'm not familiar with Indonesian law, but thanks to Ali, so I learned a little bit Indonesian law. So, and as far as I understand, in the Indonesian legal system, Law of Republic of Indonesia about the sea, number 32, 2014, is vital in the context of maritime law enforcement. Especially its part 9 provides defense, security, law enforcement, and safety at sea. Among many provisions, I found Article 59 interesting. According to this article, enforcement of the rule of law and in Indonesian waters, seabed and the ground beneath it, including natural resources contained in it, as well as sanctions for the offense carried out in accordance with the provisions of the legislation and international law. By referring to international law, this article seems to demonstrate Indonesian attitude to comply with international law rules in its maritime law enforcement activities. So next, I would like to deal with the Chinese domestic law because of the following two reasons. First, China is geopolitically important for both Japan and Indonesia. So Japan faces China across the East China Sea, and so does Indonesia across the South China Sea. Second, so China has recently adopted the new Chinese Coast Guard Act, Chinese Coast Guard CCG Act. It entered into force at the beginning of the last month. Actually, this new legislation is really controversial. So, Program Director of CSOP, so Mr. Aristo Rizka Daumawan, so also wrote an article on this new legislation. And according to the Chinese government, so this CCG Act was established to provide CCG with a legal foundation and a guideline of law enforcement activities. And as far as I understand, it strengthens the CCG's military character. And this act is supposed to be applied to the Chinese jurisdictional water according to its Article 3. However, this jurisdictional water, the meaning of this jurisdictional water is very vague, I have to say. In fact, the draft text of this act, which was publicly announced last November, has a definition of jurisdictional water. And according to that definition, So according to Article 74.2 of that draft text, in addition to internal waters, territorial waters, contiguous zone, exclusive economic zone, and continental shelf, other waters under the jurisdiction of the People's Republic of China was defined as jurisdictional water, and probably this other water includes the South China Sea, to which China claims its sovereignty. And when I look closely at this new CCG Act, I found it would violate international law. So frankly speaking, I personally do not consider that the enactment of this new act itself violates international law, because we are not sure what jurisdictional water means. So if China applies this act only to its territorial water, it might not violate international law. So whether states violate international law or not mostly depends on its application of domestic law and not enactment itself. However, I have to say that some provisions of this new act would be a cause of future Chinese violation of international law. I listed 3 consecutive articles, Articles 20, 21, and 22. Article 20 provides that CCG may remove the facilities built by foreign organizations and individuals in China's jurisdictional waters. If this foreign organization includes foreign government and this act is applied to the South China Sea, the application of this act would be a violation of the UNCLOS. So this is because this article enables China to remove facilities built by Philippines in the Filipino waters, because China still maintains its position that most parts of the South China Sea belongs to it, even after the arbitrary tribunal rendered that the Chinese claim of 9-dash line is invalid under the current international legal framework in 2016. So next I want to highlight Article 21. And so this article stipulates CCG has the right to take measures such as deportation and forced towing, even against foreign warships and government ships when they violate Chinese law and do not follow the instruction of the CCG. So this fact manifestly said that CCG can take some enforcement measures even against foreign warship as well as government ship. If this provision is actually provided as it says, it is highly likely to constitute a violation of immunity enjoyed by other states' public vessels. So lastly, I will address Article 22. So this article provides that CCG has a right to take all necessary measures, including use of weapons, when Chinese sovereignty, sovereign rights, and jurisdiction are infringed or almost certain to be infringed by foreign organizations and individuals. To be honest, it is a little bit difficult for me to understand the aim of this provision and what it means. However, this provision can be interpreted to provide a legal basis of CCG to exercise the Chinese right of self-defense, which is guaranteed under the UN Charter, because it's supposed to be triggered when its sovereignty is infringed. However, so this article looks to allow CCG to use force even when there is no armed attack, which is required under the UN Charter. So depending on its application, Article 22 can be a cause of the illegal use of force by China. If China added the condition in accordance with international law in this provision, as Indonesia does, the surrounding states would be relieved, and this new act has not been criticized so harshly. In this way, how to formulate domestic law is very important from the perspective of international law as well. So conclusion. So currently, the international community has many challenges at sea, such as sea level rise or marine plastic debris. In the context of maritime law enforcement, IUU fishing, piracy and armed robbery at sea, and other transboundary crimes such as trafficking. So, and one of the recent features is that they are committed by international criminal organizations. Therefore, international cooperation is essential to tackle these challenges. And as we see, we must note that many rules of international law are applied to maritime law enforcement activities. Therefore, for the sake of promoting the common understanding of international law globally is essential. Then, how should we foster the common understandings of rules of international law? As an expert of international law, I have to confess that rules of international law are difficult. Even for experts who study international law every day like me, it is still very difficult. So if you study international law, you can easily find out that even judges sitting in international courts and tribunals have different understanding of international law. So I can imagine that it is extremely tough for the people who make a political decision, such as politicians, to have a common understanding with colleagues all over the world. In order to foster this common understanding of international law, we have two methods. They are not new at all, but still resilient and reliable. So first, recourse to international courts and tribunals. If all states accept the authority of such courts and tribunals and follow their decisions, common understanding is strengthened. Actually, after the UNCLOS entered into force, and the UNCLOS tribunals started to their own tasks, the number of international litigation on the law of the sea has dramatically increased. So this is one of the factors to concretize the content of maritime police law, as I explained in this lecture. Moreover, last year, Singapore and ITROS signed model agreement to enable the tribunal to sit in Singapore, so Asian states can bring the dispute before ITROS in Singapore. Asian states, including Japan and Indonesia, have easier access to ITROS and are expected to utilize it when a dispute on interpretation and application of the UNCLOS arises with another state. Second, public discourse and dialogue at the global level. So this lecture can be a kind of such discourse, I think, but a more effective one is state-to-state communication. I would like to introduce the reactions by states against the submission by Malaysia to the Commission on the Limits of Continental Shelf, CSOP-CILS, on the outer limits of the continental shelf in the South China Sea. This submission is done by Malaysia in order to acquire the recommendation of the CSOP-CILS to extend its continental shelf beyond 200 nautical miles. So this is a list of state reactions. Sorry, so the letter is very small, right? But you can see that. So the red circle one is written China. So China has made many statements. Again, so this is not Chinese submission. So this is a submission of Malaysia. So I have to say it is unusual that so China made so many submissions. So China is not the state which makes submission, but original submission, but make many submissions. So why did China need to make so many statements? Can you imagine? The first Chinese submission is against the submission by Malaysia, claiming the Malaysian submission, claiming that the Malaysian submission infringes the Chinese sovereignty because it overlaps with island which China claims sovereignty in the South China Sea. However, this Chinese statement has been criticized by many other states. So beginning with Philippines, so Vietnam, Indonesia, and non-Asian states like United States, Australia follow. So let's look at the Indonesian submission. So green one is Indonesia. So in its submission, Indonesia said that actually it's an official translation conducted by the United Nations Dualos, but I rely on this translation. So Indonesia retaliates that the 9-dash line map implying historical rights claim clearly lacks international legal basis and is tantamount to upset UNCLOS 1982. This view has also been confirmed by the award of 12 July 2016 by the tribunal that any historical rights that the People's Republic of China may have had to the living and non-living resources were superseded by the limits of the maritime zone provided for by UNCLOS 1982. So in this way, so Indonesia made a submission, and in this year, yeah, so this one, so this the green one, at the bottom, is a Japanese one. So Japan also conquered it, and Japan said, so China mentioned the freedom of navigation and the overflight in the South China Sea in the note verbal number CML 63 2020. The freedom of navigation and overflight must be guaranteed in sea and airspace surrounding and above maritime features found to be low tide elevations that do not have territorial sea and territorial airspace of their own, as stated in the award of the South China Sea arbitration dated 12 July 2016, which is final and binding on the parties to the dispute. So as this fact indicates, criticizing and perjuring a state which looks to conduct illegal activities at the international forum is expected to change its attitude. And in this context, the judicial decisions are useful. As you can see, both states, both Indonesia and Japan, refer to award of arbitral tribunal under Annex 7 in 2016. So in this way, the first method and the second method, so recourse to international courts and tribunals and public dialogue and discourse, can work together. And lastly, I want to stress that coastal states law enforcement based on international law contributes to the rule of law in the oceans, in the global oceans. So law enforcement is conducted to enforce the law. But if it is not in conformity with international law, it can be another cause of trouble and consequently lead to the legal disorder. So law enforcement would lead legal disorder. It is ironic, and when coastal states engage in law enforcement, they must comply with rules of international law based on its shared understanding. So this is the end of my presentation, and so but still we have much Q&A times. So I'm willing to exchange views with all of you. Terima kasih, thank you very much, and ありがとうございました。
Thank you very much to Professor Seta for his very interesting and insightful presentation, and I hope all the audience can get the context and also the understandings, the knowledge that Professor Makoto has shared. So from his presentation, I would like to highlight a number of important issues that here it is important to be understanding in the concept of sovereignty and the sovereign right, in which sometimes people and also relevant legal enforcement didn't know how to differentiate about this concept. And in that case, in implementing those rights and obligations, policing act as a legal enforcement also becoming a very crucial one to be pay attention to, because sometimes not only to domestic incidents, coastal state also needs to respond to the foreign elements that might be intruding to national jurisdictional waters. That is why the use of force, in this case by legal enforcement agencies, is very much to be very careful to be conducted, in which two elements needs to be regarded: necessary and reasonable. This is something that we all as sovereign states and also coastal state needs to be pay attention to. And then, despite that we have a sovereignty to make our own laws, we have to make a due regard and should respect the limitation under international law, in which we should not intruding to the other sovereignty as well. And we know that certain limitation, such as the immunity of warship and government vessels, need also to be taken into account. And lastly, it is very interesting to get to know about the so-called the discussion or the debate formally under the Commission on Continental Shelf submission between China, Indonesia, and also Japan, in which this kind of note verbals is very important to be acknowledged, because this is something we regarded as the consistent policy of each of state. For Indonesia ourselves, we need to put this into writing, because we have to make sure that our position in terms of respecting UNCLOS and also respecting the decision of the PCA needs to be consistently upheld.
Yeah.
So I guess most of them are really crucial to be discussed. Of course, as an international expert like Professor Makoto, it's very difficult to address this in certainty. However, we as an international community, it is important to uphold the rule of law, especially the rule of international law.
Yeah.
All right, I guess the audience have so many questions, and before I go on to the questions, I wish to thank to the Embassy of Japan in Jakarta for their generous support in holding this event. And also, I guess before the end of this seminar, the committee will send out to you a questionnaires in which we wish to want to know about your comments and also improvement of these events for the future. All right. So there are so many questions here from the chat box, but before I read this on the chat box, I wish to offer to our dear participants, whether anyone who wish to ask the question directly to Professor Makoto, you can use raise hands feature if you wish. Otherwise, I will go on to the first question that is posed by Mr. Humphrey. Sorry, yeah, Mr. or Mrs. Humphrey here from the Secretariat General of the Indonesian Parliament. It is asked that at the beginning of 2021 or late 2020, yeah, Indonesia, along with 14 other countries, signed the agreement, yeah, on the sustainable ocean solution. So if you go to the internet, it is not the agreement as a hard law. This is more on the commitment. It's more on the declaration of the state that they will make a better a policy in terms of managing their oceans. Yeah. So the question is whether this approach can address the jurisdiction breach or on the IU fishing in the South China Sea. That's the first question. And the second question, Indonesia wish to become global maritime fulcrum, yeah, and can this aspiration be reduced by many states' competition to pursue economic resources in the South China Sea area? So I guess the first question, Professor Makoto.
Okay, so yeah, as for the first question, so the so Indonesia, especially with ASEAN states, made a kind of a document, so which is not legally binding, right? But so it is aimed for achieving sustainable ocean solution. So to what extent it is useful for to combat against IUU fishing is a kind of a question. So as far as I understand, and I believe that it would be helpful to some extent. And sometimes I'm not sure whether it's widely said or not, but in Japan, it is said that ASEAN way is like a kind of relying on the soft law instrument and not hard law. And basically, I can say that including China, so many Asian states prefer to the kind of a soft law document and not a hard law. So they wouldn't like to be bound by international law. So probably one of the reasons is that kind of a history and also perception, because international law is originally made by Western states, and so which has a power at that time, and it still be occupied and operated by Western states. Yeah, in that sense, I understand that point. But if you would like to recourse to the kind of international adjudication, such as the ICHROS or the arbitral tribunal, so they can only apply international law. So that means a treaty or customary international law, basically. And it's a little bit difficult for them to apply the soft law documents directly. So from that perspective, so if possible, it might be, I think, I'm not, so its wording is a little bit difficult, safer to select the kind of a hard law document, because irrespective of whether the document is hard law or soft law, probably the application and interpretation, the dispute on interpretation and the application can happen. So, and in order to solve that such dispute, I think it is better for us to rely on to recourse to the third judicial independent organ. And in that case, I think the hard document have kind of advantages. But I understand that, so it's easier for states to make a soft law document. So first making soft law, and after, if it's possible, or if there kind of a consensus, the state parties consensus appears, so they can change it to the hard law, might be a kind of a future step. And actually now, so there are many activities to tackle against IU fishing, and also, it's my personal impression. So we cannot say which one is the most effective or which one is not effective. But what we can do is, so we just do all we can do. So in that sense, so this new approach is also really nice. So to tackle, to fight against IU fishing. So, and I'm not sure to what extent I understand the second point. So Indonesia want to be a kind of a maritime industry state, or so what is it? What Indonesia want to be?
Yes, it is. We can assume that, so we can be, let's say, more powerful state in terms of the economy in the area.
Okay, and sorry, what the question? I'm sorry.
So because of so many competition within the area of South China Sea, whether the aspiration of Indonesia to become a more dominant role in terms of economic resources, will it be affected by the conflict in South China Sea?
Okay. So thank you very much. It's a very clear question. Thank you. Yes, yeah, it's a really tough question. So actually, of course, it's up to Indonesia. So if I believe that, so as I said, so both Indonesia and Japan ratify the UNCLOS, and many states surrounding South China Sea ratify the UNCLOS. I can say almost all states. And if they comply with the rules of UNCLOS, so and so far as so far as Indonesia so comply with the rules of UNCLOS, it would not be it cannot be a serious problem. So because they just follow the provisions of UNCLOS, and it's obvious that all states decided to join UNCLOS by knowing the content of the UNCLOS. So they have the obligation, of course, they have the obligation to comply with the UNCLOS. So if Indonesia would like to develop and to be powerful in the region, and for that purpose, if it use maritime resources, so of course fishing resources and also the other mineral resources in its vast maritime area, and successfully develop. But if it comply with the UNCLOS, it would not be, it wouldn't cause a serious problem. So this is what I believe at this moment.
Okay, thank you very much for your clear explanation, Professor Makoto. So next, I would like to give the opportunity to Associate Professor Gregorius Sri Nurantio. Pak Sri, you can unmute yourself.
Okay, thank you, Pak Ari, for this occasion. Good morning, Professor Makoto Seta. Yeah. I would like give a comment and need your reply relating the condition in the South China Sea, particularly relating the complaint was made by People's Republic of China based on the Nine Island. Yeah, and until nowadays, yeah, in many occasions, the fisheries from People's Republic of China sometimes still entering the economic acquisition to Indonesia, yeah, in Indonesia, and Indonesia always try to enforce the regulation based on UNCLOS and also based on Indonesian regulation. Yeah. If you are an Indonesian side, yeah, because you are never conflicting relating with the people. What should we do, yeah, for the best way to solve the problem? Yeah. And then secondly, even People's Republic of China know well that the UNCLOS should become the completely convention regulated all the international law of the sea. But after conflicting between People's Republic of China and Republic of Philippines, yeah, into permanent court arbitration based on the UNCLOS mechanisms, yeah. I think until now, this China is never to obey the judgment was made by the permanent court of arbitration relating to UNCLOS, yeah. What do you think about it? Yeah, it is very, very important for us, yeah, to know the enforcement of the UNCLOS for all international community. Thank you very much, Mr. Seta.
Yes, Professor Makoto.
Okay, so thank you very much for your questions, Professor. So yeah, it's really difficult to be against China. So because China is now one of the most powerful states. So now it's competing with the United States, and yeah, I know that some kind of AUV are deployed to Indonesian waters, and they were found in Indonesian waters, right? And within the exclusive economic zone and the continental shelf, of course, Indonesia have the sovereign right and jurisdiction to manage its own resources. So as far as the UNCLOS allows, of course, Indonesian can take some measures. So just pick it up and so just examine it, and also the if some factors of criminal, or so if it's against the Indonesian law, so the law enforcement should be conducted. So it's allowed. So this is a kind of a one measure which can be taken against China. And also the second one is the second issue is that to what extent the China respect the UNCLOS, and so actually China looks not to respect it. So because it manifestly said that the arbitral award is null and void. So against this, I think, position, it's quite difficult for the other state because it's a kind of a challenge against the UNCLOS system itself. So, but I believe that no state wouldn't like to go to the war, right? But so actually now, states surrounding China feel the kind of impression that China is aggressive and it would expanding its maritime area. So I think it's important for the other states to get together and cooperate, and claiming that the Chinese understanding of law of the sea is kind of long. So, and actually now it is being conducted at the CLCS. So that's why I find that the CLCS discussion is kind of useful. Or in other words, all other states can do is just claiming, I think. So of course, so yeah, some people might argue that so use force, or so some other coastal states also strengthen their law enforcement activities in the disputed area. So that might be one alternative. But so as a lawyer, I wouldn't like to rely on the kind of a physical power. So, and I believe the kind of the humanity of all people and all states. So I might be too optimistic, but I think that the kind of the strategy to be taken at this CSOP-CILS now is a kind of a good way. So not only Indonesia, not only Philippines, but also other states. So many states, if the number of states increase, probably it would give an impact on China as well. So, and there are many state parties to the UNCLOS. So that just to get together and claim that the superpower activity is wrong, or it's not in conformity with UNCLOS. So that is kind of a shared understanding. It might be, China might have the different understanding, but the shared understanding is like this. So this kind of a strategy should be taken. So this is what I'm feeling. So thank you very much. And I'm sorry that so my answer might not fulfill your expectation, but what I can say is this. Thank you.
Thank you very much, Professor Makoto, and thank you very much, Pak Sri, for your question. And now, as you may aware that our event is also broadcast live through YouTube, and we have a question from the audience in YouTube. It's from Mariska. She posed a question: how Indonesia's maritime officer can encompass the principle of necessity and proportionality according to ITLOS, according to your opinion, Professor Makoto? And also, does using weapons to protect jurisdictional waters, although it has been regulated in national law, interfere the international relation of the states involved? And if I may add, there has been a trend in weaponizing the Coast Guard. There's a data suggested that the expenses in upgrading a weapon of Coast Guard is now almost the same with the weapon of the Navy. Professor Makoto?
Okay, so thank you very much for questions. And yeah, as I said, I'm not expert on the Indonesian law, so I'm not sure whether I'm appropriate to answer the first question. So how Indonesia incorporate proportionality and necessity principle into domestic law. But as I said in my presentation, so Ali gave me the kind of a document on the Indonesian law, so English version. So sorry, I can't read the Indonesian languages. But as far as I understand, so it said that the law enforcement carried out in accordance with international law. And as I said, now I think that probably some other academics might have a different opinion, but I think that currently the principle of proportionality and necessity or reasonableness is applied to all the maritime law enforcement activities in the all maritime areas. And so if the Indonesia carry out its law enforcement in accordance with international law, so they must comply with the proportionality and necessity. And actually it is written in the Indonesian domestic law. So yeah, at a first glance, at least we can say that the Indonesia comply with that principle. And so next question is with regard to the jurisdictional water. So actually I have to say that the jurisdictional water is a kind of a unique term used by China. So kankatsu suiki in Japanese, so jurisdictional water, but I'm not sure whether you know or not, but we Japanese share the Chinese character. So we understand the meaning of the Chinese character to some extent. And it sounds like a jurisdictional water. And actually, if foreign state attacks against the territorial water, for example, so it might constitute a violation of sovereignty because coastal states have the sovereignty over territorial water. Actually, North Korea launched many missiles and it falls at the exclusive economic zone of Japan. And some Japanese ordinary citizens think that it's a kind of armed attack against Japan. But from the perspective of expert of international law, especially law of the sea, it is not. So because exclusive economic zone is just an exclusive economic zone, and Japan does not have sovereignty over the exclusive economic zone. So most rules of the high seas are applied. I'm not sure whether the freedom of the high sea allow North Korea to launch the missile into the high sea, but anyway, it's not a violation of Japanese sovereignty. So in this way, so under the UNCLOS framework, so as Ali also highlighted, we must separate or we must distinguish between sovereignty and sovereign rights and jurisdiction. So but the problem of the Chinese new act is that it looks mixed up. So it just says jurisdictional water, and it looks to cover the maritime area which is even not regarded as exclusive economic zone, neither exclusive economic zone nor continental shelf, so not provided in the anchors at all. So yeah, it looks very problematic. And so the law enforcement activities within jurisdictional water, of course, can be a serious problem, diplomatic problem, because as far as I guess, this jurisdictional water covers the South China Sea and the Filipino exclusive economic zone. And if so, Filipino activities conducted in Filipino exclusive economic zone from the perspective of Philippines and also the, I think, shared understanding of international law of the sea. So those activities could be hindered by the Chinese Coast Guard. So it would be a kind of serious problem. So that's why I feel I have to criticize this new Chinese enactment. Okay, and yeah, I know the fact that recently many Coast Guard are weaponized. And of course, to some extent, it's understandable because recently criminals use a heavy weapon, right? So especially in the case of Japan, so Japanese Coast Guard officers were deployed to off the coast of Somalia, but actually the Coast Guard, JCG, is not established for that purpose because as its name shows, so the main function of the Coast Guard is protecting the kind of a coastal area, right? And not off the coast of the far away. So actually in that case, so Japanese Maritime Self-Defense Force was also used. So the Coast Guard officers were deployed on the Self-Defense Force vessel and went to off the coast of Somalia. But the pilots in Somalia used very heavy weapons, so they were armed. So in order to fight against these criminals, I think so Coast Guard must be weaponized. So to some extent, it's understandable. And so there is a kind of incident between South Korea and China that in that case, a Chinese fisherman killed the Korean Coast Guard. So actually, so such tragedy happened. So in order to fight against such criminals, so to some extent, the Coast Guard must be weaponized. But what I want to emphasize here is that, yes, Coast Guard agencies might be weaponized now, but they should refrain from using that force against another state. So the criminals of another, so criminals, foreign criminals is, of course, okay, all right, so no problem. So Coast Guard sometimes use police power against foreign criminals. And it happens all over the world, I think. And in the case of the ocean, so it's connected all over the world. So sometimes foreign people came and engage in criminal activity. So they must be surrendered by the powers, physical powers. And so in that case, Coast Guard can utilize its power, but against another state, so I mean the public vessel like a Navy vessel or Coast Guard vessel should be refrained. And if the Coast Guard agency use such power against another state, it highly constitutes a violation of international law. So current international law doesn't allow it. So this is my understanding. So thank you for your question.
Thank you very much for that extensive explanation, Professor Makoto. Okay, if I may continue to the next question. So this is a question from Renata Auli from Faculty of Law, Universitas Padjadjaran. She asked that RECAP was initiated by Japan to prevent and suppress piracy and armed robbery against ships in Asia. The state parties need to share information about piracy and armed robbery as an implementation of the principle of duty to cooperate, which is stated in Article 100 UNCLOS 1982, which is stated also under Article 44, states have duty to share information about the dangers to navigation in international trade. The problem is Indonesia doesn't want to cooperate by giving information about armed robberies which happen in our territorial waters. But however, I need to correct this because now we have the Indonesian Maritime Information Center, in which it is under the Indonesian Coast Guard or Badan Keamanan Laut, that we are provided every information or incidents or any type of criminals that it can be accessed into the website of IMIC, yeah, Indonesian Maritime Information Center. On the other hand, Indonesia also right to ratify the recap, not to ratify the recap, because of Pacta Sunt Servanda. Well, this is not about the Pacta Sunt Servanda. Pacta Sunt Servanda is apply when you already sign the treaty. So it's about the sovereignty, whether you want to ratify or not the treaty. And then Renata said, we are faced with two most fundamental principles in international law as a coastal state, duty to cooperate and Pacta Sunt Servanda. So the question is, which principle is more important according to Professor Makoto?
No, some other voices I can hear. Okay,
yeah.
now it's okay. Yeah.
Okay. Right. Which principle is more important? Is it cooperation or Pacta Sunt Servanda? And would you recommend Indonesia to ratify a recap?
Okay. So thank you very much for your question. Yeah, actually, I strongly recommend the Indonesian government to ratify the recap. So I hope it, but I also understand the kind of Indonesian position. And actually, as Ali said, that so Indonesia has a discretion to decide whether it ratify the recap or not. So in that sense, of course, so Indonesia can choose not to ratify the recap. So yes, if so, as far as I understand, so the Indonesia is not bound by the recap. And sorry, so going back to the obligation, so duty to cooperate, as far as I understand, so it is a kind of a information sharing on navigation. And of course, now it might be possible for us that information on piracy and armed robbery at sea is relevant for navigation. So that information is also covered in the duty to cooperate, but probably historically speaking, or literally speaking, or so once at least it was established to share the kind of information on the climate condition, for example, so what kind of waves came, or the ship sank and the wrecks still remained in that area, or those kind of informations are supposed to be shared under the UNCLOS framework. So in that sense, even though Indonesia doesn't share the information on the armed robbery and also the piracy in the Indonesian water, so probably it wouldn't lead to the Indonesian violation of the UNCLOS provision, or especially duty to cooperate. So this is my understanding. So I think, as far as I understand the current provision of the UNCLOS, so they do not contradict each other. So Pacta Sunt Servanda and duty to cooperate. But if the law develops, and if the law develops, and if the, for example, if some tribunals, court and tribunals said that so now the duty to cooperate includes the information on piracy and armed robbery sharing is included. So now, so at that stage, Indonesia has a duty to cooperate, but still, I think it does not contradict with the Pacta Sunt Servanda. So because it might be true that the Indonesia doesn't ratify the recap, but it ratifies the UNCLOS. So if the UNCLOS duty requests some information sharing, so Indonesia also has to comply with, so has to obey that, fulfill that obligation, that duty. But now, this moment, I don't think that the information sharing does not request such information. So this is my understanding. So thank you for your question.
Thank you, Professor Makoto. And there's another question from Renata, actually. She asked, why does information sharing system need to be located in Singapore?
Okay, so thank you very much your question. And actually, I had that one of the kind of a complaint, Indonesian complaint, is that the information sharing center should be located in Indonesia, right? And also Malaysia claimed it. So, and sorry, to be honest, I don't know. So it's just a political decision, right? So, and I didn't participate in the diplomatic negotiation, so I don't know why. But for me, so yeah, it's understandable. So because So Singapore is also located in the kind of a Strait of Malacca. So actually, when the RECAP was established, the armed robbery at sea at the Singapore and the Malacca Strait was really problematic. So in order to replace armed robbery at sea at the Malacca Strait, so Singapore can be a good location. Of course, Indonesia and Malaysia can be a good candidate, but actually, it's kind of my personal view. But I have the kind of impression that the Malaysia and Indonesia have a kind of a rivalry relationship, right? So if state parties establish the center at the kind of Malaysia, okay, it's difficult. It's more difficult in Indonesia to ratify, and if it's established in Indonesia, more difficult for Malaysia to ratify. And actually, probably so I'm not sure the Japanese government view, but other states might consider that they need a kind of a cooperation of both two states. Okay, so Singapore might be a developed state, but it's a small state, so it can be a neutral, and so we can just put the center as the Singapore to ensure the kind of a neutrality between Malaysia and Indonesia. So yeah, I just come up with the location of Canberra. So Canberra is capital city of Australia. And there is a kind of a rivalry relationship between Sydney and Melbourne, so large city in Australia. I'm sure that Ari knows better than me, but so as a result of this rivalry relationship, so Canberra was designated as a capital city. So it's not so attractive, or so, but it's small city. But yeah, it's the capital city of Australia. So in this way, so concerning these factors, I think it's understandable that the CAP has its information sharing center at the Singapore. Yes, thank you for your question. And sorry, I have to say I don't know the exact reason. Yeah.
Yes, indeed, Professor Makoto. I think Singapore has been, in many occasions, become the place that, as a political decision, Singapore had become the location that we Indonesian wish that location be in Jakarta or somewhere else in Indonesia.
Yeah, it's also understandable. I can imagine. Yeah.
Okay, so again, for participants who wish to ask a question directly, please feel free to use the raise hand feature so that I can identify your identity. And if I may continue the question from Erlangga, it is said that in UNCLOS there should be no capital punishment for any violation to the jurisdictional waters. However, the criminals who committed illegal fishing, they cannot pay the fines, and eventually the judges gave the subsidiary punishment by putting them in the prison for a certain time. What is your comment on this? And do you think that whether the period of, let's say, in detainment in terms of the investigation also be part of the prohibition on capital punishment under UNCLOS, or it is only for the punishment made by the judges? And maybe you can share your context in Japan, whether Japan legal system has made or implement the fine system for any violation to, let's say, illegal fishing. Professor?
Okay, so yeah, thank you very much for your question. Yes, it's provided in Article 73 of the UNCLOS, right? And actually, so first I want to emphasize the fact that not only capital punishment, corporal punishment, but also the imprisonment is also prohibited generally. So if state parties to make a kind of agreement to allow imprisonment each other, it's allowed under the UNCLOS framework. But generally speaking, so coastal states cannot impose imprisonment punishment against foreign fishermen. So this is the kind of a basic reading of the UNCLOS. And actually, so Japanese government, Japanese policy adopts such, I think, policy. So Japanese government tries to comply with the law of the sea. And once it was discussed that actually, so Japan also suffers from the illegal fishing conducted by foreign nationals, especially from China and also South Korea. And once the surrounding Ogasawara Island, so there is a kind of a very beautiful coral reefs, and if the fishermen take coral reefs and they take it and go back to China and to sell it, it would be a huge amount of money, and so there is a kind of incentive for Chinese fishermen to violate Japanese regulation. And at that time, actually, it was discussed that some people claim that so imprisonment should be introduced against the foreign fishermen, even in EEZ, but it's contrary to the UNCLOS provision. So what Japanese government did is just raise the kind of a punishment fee. So that's so this is the kind of a Japanese understanding of the UNCLOS 73, and I agree with it. So if the coastal states put the detain the suspect engaging in illegal fishing, so it would constitute a violation of the UNCLOS. So because, as I said, imprisonment is not allowed. Of course, technically speaking, it might be possible to say that, so it's not the imprisonment punishment, it's just detained in the proceeding or the kind of other reason. But from the perspective of international law, and also the reason why this 73 is guarantee the fisherman right is that it take a balance between the coastal state, interest of coastal states, and the interest of the flag state, and also the fishermen, the freedom of the high seas. So as I said, so we must separate the sovereignty and sovereign rights, and EEZ is not subject to sovereignty. So of course, Indonesia has the kind of a right and so to protect its own interest, and for that purpose, so some law enforcement activities are allowed. But if the imprisonment is prohibited by the UNCLOS, so of course, so under some kind of a detention, so detention, whatever reason they rely on, so it can be regarded as a kind of imprisonment. So it should be avoided. So this is what I feel. So if I misunderstand the kind of a current situation of Indonesia, so please let me know. But so this is what I understand and what I'm thinking about it. So thank you for your question.
Thank you very much, Professor Makoto. There's a question from Rafiq Arik. He asked that whether the enforcement against the environmental pollution at sea that caused by the oil spill from the vessel in accordance with Article 233 be enforced against the foreign vessels that navigate in within the international strait, because in that kind of international strait, there is a right of transit passage of non-sustainable passage.
Sorry.
So in international strait, yeah, there's a right of transit passage, which is non-suspendable. So whether the coastal state can make enforcement against this foreign vessel who's navigating through that strait.
Okay, so yeah, it sounds a very tough question. Yeah, sorry. As for international straits, so yeah. So basically, Part 12 is applied to all maritime areas, and also the as for the maritime pollution. So the UNCLOS said that except territorial water. So basically the only monetary penalty can be imposed against the foreign vessel. So this is the kind of a rule which is provided in the UNCLOS. So to be honest, I've never considered the relationship between the international straits and that provision. So yeah, I have to study it. So I don't have so I have to confess that I haven't studied the relationship between these two rules. So it's my kind of impression. So, but I might change my opinion in the future if I study. But so at a first glance, or as far as I understand, so probably it's a little bit might be difficult for coastal states to impose the kind of a penalty other than monetary penalty, because international straits, the freedom of navigation of the international strait is strongly protected. So that strait is very unique and special. So considering that fact, so its nature is similar to high sea, and the right of the coastal state is quite limited. So if we consider in that manner, it might be regarded as a violation. So if the coastal states impose the kind of a punishment like so detention or detaining the vessel, so it would constitute a violation of the UNCLOS. But actually, as for the maritime pollution, what I can say is that prosecuting, of course, in the criminal context, it might be important to prosecute some seafarers who is in charge of the incident. But as for the kind of a damage against environment, I know that it takes a huge amount of money. But now, so in the there are many treaties to support the kind of a damage from the for example, collision or the kind of oil pollution from the vessel, like Bunker Convention, for example. So actually, one of the Japanese-related vessels sank near the coast of the Mauritius last year. And so that actually flag vessels, the flag state is the Panama or Bahama, or so one of the flag of convenience state. So it's not Japan, but it was operated by Japanese maritime company. And okay, so the maritime pollution occurred in the near the coast of Mauritius. So if the actually, so what I want to emphasize here is that the compensation is done through the kind of international mechanism like a Bunker Convention, and also recently the many shipping companies are expected to protect the maritime environment. So there's a kind of a pressure to pay some money to contribute to the cleanup mechanism. So as actually Japanese maritime shipping company also engaged in the cleanup activities. So in this way, even if the coastal states do not take a strict criminal sanction or criminal punishment, so sometimes the other mechanisms work quite well, and the maritime pollution, especially pollution from the oil, can be recovered, or at least I can say that financially can be supported by the international community. So this is my understanding. So sorry, as for the direct question with related to the international strait and the Article 233, so I have to study it. So thank you very much for your difficult question.
Thank you very much, Professor Makoto. If I may add, if we compare the international strait, if we're looking at the Malacca Strait, there's a part where it's overlapping territorial waters between Indonesia and Malaysia, and therefore there's a right of non-suspendable innocent passage if the pollution is occurred in that area, so that the innocent passage elements is no longer fulfilled. That is why the rights of that transit can be enforced by the coastal state. In this case, whether Indonesian officers or Malaysian officers. So that's my just 5 cents.
Yes, it's true. Yes, yeah. So yeah, international right. Sorry. Yes, but so I'm not sure to what extent the transit passage is guaranteed, right? So it's international strait, so transit passage is, in my image, stronger than the innocent passage, right? Of course, it cannot be regarded as innocent passage, so you are right. I agree, totally agree with it. But with regard to the transit passage, it might be a little bit difficult to make a clear-cut answer. So compared to innocent passage, yeah. As for innocent passage, as you correctly point out, that so it's not innocent anymore, right? Yeah. I understand. Thank you. Thank you for.
All right. Thank you very much, Professor Makoto. And there's a question from Yeskel from the Ministry of Environment and Forestry. The first question: how about the management of the marine pattern and the coastal areas in which in Indonesia that the authority between the central government and the regional government is divided. So between the 0 to 4 nautical miles from the baseline, it is the authority of the provincial government. And then for the areas more than 4 nautical miles and the regional waters until the EEZ, it is the authority of the central government. How about in Japan? Is it the allocation of authority is the same or different? And then the second question, how is your view on the South China Sea claimed by the Chinese Malaysia? Well, I have to say that Indonesia is not claiming some part of that because we are not non-claimant state. So I guess, but your opinion in general of the South China Sea, Professor?
Okay, so as for the first question, so I wouldn't like to speak ill of the Japanese government in front of the staff of the Japanese government, but actually, I think it's a weak point of the Japanese system. So there is no kind of a clear-cut distinction of the authority in charge of which maritime area, especially the local government and central government. And I think that those kind of a distinction should be clearly lined. And as far as I know, in the case of Australia and the United States, up to 3 nautical miles, state government have the authority, and beyond 3 miles, as far as I remember, the federal government have the authority. So in this way, I think many states adopt the similar system, similar to Indonesia, right? So it's a little bit different from the, because in the case of Indonesia, you said 4 nautical mile, right? But I think it's reasonable. So as for the kind of off the coast, far away from the coastal line, I think the central government should take the kind of a unified policy. But in the coastal area, so there are many stakeholders, and they might have easier access to the local authority. So the local authority should have the power. And actually, in fact, probably Japanese coastal line are operated in such a way, but we do not have a kind of a clear legislation on that point. So actually, it's a matter of Japanese domestic law. But so I'm not a specialist on the Japanese domestic law, but sometimes I say that so that kind of legal system is needed. So that's my personal impression. So in that sense, so Japan cannot be a kind of a reference for the Indonesian policy. So yeah, I have to say. Okay, thank you for that question. And also, as for the South China Sea, yes, as Ali mentioned, that so actually in the statement in the CSOP-CILS, so Indonesia also clarified its position that Indonesia is not claiming any area of the South China Sea. So in that sense, it's not relevant, directly relevant, but still Indonesia believes that China should comply with the arbitral award in 2016. So this is a kind of a Indonesian position. And so the question is the relationship between Malaysia and China in general, as for the South China Sea. So I'm sorry, I'm a little bit confused with the question. Yeah, okay, I'm sorry.
Yeah, so it's your general opinion about the South China Sea conflict.
Okay, thank you very much. Yes, so yeah, as an international lawyer, so I expect that all states comply with rules of international law. And so rules of international law are concretized by the judgment and award of international court and tribunals. And as for South China Sea, so the arbitral tribunal rendered a decision. So I expect that all states shall comply with the award. So actually, so this position is the same as the government. So, but sometimes, of course, I have a different opinion from the government. But in this point, I support that position. So all state parties to the UNCLOS shall comply with the UNCLOS. And actually, sometimes I often asked my Chinese colleagues that why China ratified the UNCLOS, because so China has many disadvantages when ratifying the UNCLOS. So if I was recruited by the Chinese government, I strongly recommend not to ratify the UNCLOS. So when it was, considering to ratify or not. So, but now So China, so from my point, so I really, of course, welcome the Chinese acceptance of the UNCLOS, and now I expect the United States to ratify it as an international lawyer. But so once it ratifies, so it should comply with the UNCLOS. So this is what China is expected. Actually, I have also many Turkish friends, and Turkey is also one of the states which doesn't ratify the UNCLOS. And the Turkish government also know the kind of advantage it takes when ratifying the UNCLOS, but actually the kind of many rules, especially rules of the territorial water, territorial sea, and exclusive economic zone are not acceptable for the Turkey because it has many maritime problems with Greece. So Greece having the many islands in the Aegean Sea and the Eastern Mediterranean. So the Turkish government decided not to ratify the UNCLOS. So from the Turkish perspective, so China get a kind of interest by ratifying the UNCLOS, but not complying with the UNCLOS. So it's a kind of a cheating. So I understand that point. So if China would like to be a state party to the UNCLOS, it should comply with the UNCLOS. And for that purpose, the decision of arbitral award is very important. And to be honest, as an international academic, so law of the sea academic, I have some points I want to criticize for the award. But as I said, international law is very difficult, and a different lawyer can have a different opinion. And the arbitrators, so actually, so they are very distinguished academics. I know that, so they have many good career, and they know law of the sea better than me. So and they made a kind of a unanimous decision. So we should respect it, even though we have a kind of a point to criticize. So this is my position. So yeah, what I expect China is to comply with the arbitral award, and Malaysia, Indonesia, Vietnam, Indonesia, or so all other state parties should say that the arbitral award should be respected. And once, if such similar decisions are given to their own state, so they should comply with it. So this is my opinion. Thank you very much.
Thank you very much, Professor Makoto. Since we are approaching the end of the event, so I would like to apologize to the remaining question that might not be posed in this opportunity. However, I would like to ask one last question to Professor Makoto from Ibu Dia and also Ibu Emma, that they're asking about what is the latest issue of the marine issues in Japan, and maybe is there any still incidents of illegal fishing in the Japanese waters?
Okay, so thank you very much for your question. Yes, so actually it might be a little bit difficult for me to select one latest issues in Japan, because so Japan, I'm not sure, probably in the case of Indonesia, same thing, right? So we are surrounded by the ocean, so almost every day something happened on the ocean. And but a recent hot topic is the CCG Act, so Chinese Coast Guard Act, as I introduced. So that was hotly debated. But if I technically speaking, the latest one is the kind of how to deal with the polluted water by the atomic power plant. So almost 10 years ago, so great earthquake hit Japan, right? And the atomic power plant was stopped, and now we have contaminated water in Japan. And so probably, so recently, it's still, I haven't studied it deeply, so but I just watched the TV news program, and so as far as I understand, so probably the one of the solution, or maybe the sole solution is to discharge that contaminated water to the ocean. But of course, it would, to some extent, pollute the maritime area. And some states, especially it's South Korea, so claims that it would contaminate the ocean. So Japan shouldn't discharge its contaminated water to the ocean. So this is the kind of a recent topic, and I understand that some kind of a concern. So because we have a kind of we have a strong concern for the atomic power, or nuclear kind of a contaminated water. So we have a really negative image for that, so such water. So it shouldn't be discharged. But as far as I understand, of course, before discharging such water, so Japanese government takes several measures to clean it up. So after the processing the water, and finally the one which is allowed on the basis of the IAEA standards. So IAEA stands for the International Agency for the Atomic Energy, or something like that. So it's deal with the nuclear power, and so based on the standard provided by the IAEA, so Japanese government probably would discharge that water into the ocean, and it is now very controversial. Of course, it's controversial in Japan. So because the stakeholder which have a direct negative impact is probably the fishermen. Of course, the Japanese fishermen engage in fishing activities near the coast of Japan. So if such water is discharged, so probably there is a kind of a rumor that, okay, so that fish is very dangerous. So if you can that fish, so probably you might have cancer or something like that. So, but in order to avoid such criticism, and also in order to persuade the such fishermen, so Japanese government processing the discharging water, and based on the kind of a scientific evidence guaranteed by the international organizations such as IAEA. So yeah, I know that some foreign states also criticize it, but probably the Japanese government, I expect and believe that Japanese government take a decision in accordance with the international standard, and also with the method to persuade the even fishermen of engaging in the fishing activity of the coast of Japan. So in that sense, I can say that I expect that discharge is safe and not contaminating or polluting the maritime environment directly, so dramatically. So yeah, this is the kind of a latest issue might be. Okay, so thank you for your question. And actually, as I said, so there are many incidents happen, and many questions. Actually, I have many questions from the Japanese media as well. So, but yeah, many topics. And the same, I guess, same in Indonesia. Thank you for your question.
All right, thank you very much, Professor Makoto. Just one quick question. Why Japan is not consider itself as a archipelagic waters legally?
Yeah, so thank you very much indeed. And yeah, it's also, my position is a little bit different. Actually, I don't know the kind of current Japanese position, but actually, as far as I know, so Japan has never claimed the kind of status of archipelagic island states. And the reason is that when Japan participated in the UNCLOS 3, so this is the UN Conference on the Law of the Sea. So when they engage in the drafting procedure of the UNCLOS, so Japan took the position that the ocean should be open and for free. So actually, Japan stick to the 3 nautical mile territorial water. So this means that the high seas is more wider, right? Open. So now, so finally, so it becomes a 12 nautical miles. But so as this Japanese position shows that the Japan consider that the sea should be open to as much as possible. So because of course now Japan has many maritime areas, as I said, and island states, but at the same time, Japan actually relies on the maritime transportation. So the freedom of the navigation is quite important for Japan. So from that perspective, actually, so I think the interest of Japan was against Indonesia for that perspective. So because archipelagic water is so coastal states have a very huge discretion and a strong power in that area. So those kind of areas should be limited. So that might be the kind of a Japanese position at that time. So Japan didn't support the kind of idea of archipelagic states so strongly, and didn't take the Japan is an archipelagic state. But now I think that now Japan suffer from the kind of passage by the Chinese Navy, and China claims that it's a kind of international strait, so China enjoy the kind of a transit passage. But from the Japanese perspective, it's a territorial water. So now it's another kind of a legal warfare, so between Japan and China, and but I think so. One possible way from the current UNCLOS perspective is that Japan can take the it's a kind of archipelagic water, so archipelagic states, because as I said, Japan consists of 7,000 islands, so it has many islands, so similar to Indonesia, Philippines, so it has a kind of archipelagic water. So that might be a kind of a one maritime claim Japan can make, but so far, as far as I understand, Japan has never claimed it, and I haven't had a kind of any plan to claim it. So this is my understanding. Yes, but yeah, that's a very interesting question, and I think technically speaking, it can possible. I think it might be possible for Japan to claim in that way, but never made it. Okay, so yeah, thank you very much for your question.
Thank you very much, Professor Makoto, and all of your explanation very comprehensive and very wide range of insights. And it's so many important aspects that we have discussed. Unfortunately, because of the limitation of the time, and I know Professor Makoto has exhausted explaining all of the questions, and I guess Professor Makoto is willing to maybe someday you can come down here to Jakarta and give the presentation directly.
Definitely. I'm willing to.
And maybe we can go to Yogyakarta and also Bali.
Okay, great. Yeah, sounds very nice. And I also enjoy myself to exchange view with you. And I'm sorry for that. Actually, I found many questions in chat box, and I'm sorry that I can't answer all of them. But I'm really pleased to accept these many questions, and you have a strong interest in it. And so yeah, if Ali gives me the opportunity, I'm willing to go and make presentation again. So it's really nice.
Okay, thank you very much. And I also thank to all of the participants that have stayed until this time. And don't forget to fill out the attendance and also the questionnaires, and also in order to get your certificate. Professor Makoto Seta, on behalf of the Center for Sustainable Ocean Policy, Faculty of Law, University of Indonesia, we thank you very, very much for your time and your discussion. And we hope that this discussion can give everyone here a better understanding on the issue. And we hope that this is not the last time for you to give us the lecture, and we will meet again in another good opportunity. Yes. Okay, and therefore, I will wrap up this event formally by saying Alhamdulillah Rabbil Alamin, and thank you very much for attending this event, and hopefully see you in the future. Thank you very much. Bye-bye.
Thank you very much. Yeah.
Thank you very much, Professor Makoto.
Bye.
Selamat pagi, Bapak Ibu sekalian.